of changing the plan is that the Missouri plan, or the non-partisan court plan, has been dominated by trial attorneys. How would you respond to that contention?
You know, if the Missouri plan has been dominated by trial attorneys, one would think that the courts would be dominated by trial attorneys. And if you look at the history of the Supreme Court from the 70s to today, you would find that the overwhelming majority of Supreme Court judges have had nothing to do with the Missouri Association of Trial Attorneys. If it's true that MATA exercises inordinate influence over judicial selection, then one would think that we would have a Supreme Court of nothing but MATA lawyers. And that is simply not the case. It is simply not true. And if you look at the makeup of the commissioners, the lawyers who are elected by the 30,000 members of the Missouri Bar, if you look at it, you'll find that there have been an almost even distribution of lawyers who are what we call trial lawyers and other lawyers who are not members of the plaintiff's bar. There is traditionally a give and take, an ebb and flow. And while there may be might be a period of time where trial lawyers dominate the commission in one year, there might be another year in which there are no trial lawyers on the Judicial Appellate Commission. I would point out that lawyers, all of us, whether we're plaintiffs' lawyers, defense lawyers, probate lawyers, traffic law lawyers, criminal defense lawyers, intellectual property lawyers, real estate lawyers, we all elect members of the Judicial Appellate Commission, the attorneys that populate that commission. In order for a lawyer to attract enough votes to become a member of the Appellate Judicial Commission, they have to appeal to a broad base of lawyers. They can't appeal to the 1,000 members of the Missouri Association of Trial Attorneys. That's not enough of a constituency to get you elected. So you have to be fair and balanced in your approach to the judicial selection. And I think that if you look at the judges who we've selected, that is a product of very careful consideration by a bunch of very smart people who are not inclined to control the judicial population in this state by putting the plaintiff's bar on the bench, because it simply hasn't been the case.
I just echo Skip's comments. It's a red herring. This doesn't happen. The commissioners over time are balanced between different elements of the bar: defense lawyers, plaintiffs' lawyers, whether they be the Appellate Judicial Commission or the commissioners in the various counties at the trial level. It's a red herring. It's bunk. It's the big lie. It's simply not true. Over time, the commissioners have been very balanced between various elements of the bar, and it's reflected in the judiciary that they've produced, which is also very balanced, impartial, and reflects the broader spectrum of the bar.
Bob, Jason, let me add one more comment to that.
Mm-hmm.
Tom's right. It's simply a lie that MATA exerts undue influence over judicial selection in this state. If you look at the lawyer members on the Appellate Judicial Commission, you're looking at a who's who in the legal community in the state of Missouri. You're looking at the best of the best, the brightest legal minds, some of the brightest legal minds this state has ever produced. It's a Hall of Fame list of lawyers, and that's why they're on that commission. They're on the commission because they are that good at what they do. They are that smart. They are that engaged. They are that interested in a fair and impartial judiciary that the rest of the lawyers in the state recognize the excellence that they see in these candidates, and that's why they're on the commission, not because they're a member of one group or another.
If this